SJC-12697, Commonwealth v. Manuel Torres-Pagan.
Mr. Shuri, good morning.
Thank you, Mr. Chief Justice, and may it please the court. Weighing of relevant factors, of course, is appropriate in determining reasonable suspicion. But the complex inquiry into what a reasonable police officer might have suspected cannot be boiled down to simply counting generic all-or-nothing factors. I suggest that when you evaluate the totality of the circumstances here, police officer had reasonable suspicion to suspect that the defendant was armed and dangerous.
Whose driveway was it?
I apologize?
Whose driveway?
That's not clear from the record. From the record, we know it's a residence. There are some residences at that address in addition to some businesses on the first floor. We really don't know anything more about
We
it.
know where Mr. Pagan lived?
Yeah, I guess that was the follow-up, right?
I don't believe that's in the record, Your Honor. So they discussed running his.
So can you just go over the factors that make exiting a motor vehicle something that would create suspicion in a police officer?
So I wouldn't say exiting a vehicle standing alone is enough, but we have the defendant has pointed to Torres, where the court specifically says exiting in this case doesn't add to the equation at all. But in these circumstances, a routine traffic stop, two police officers that get out of their car approaching on either side, as the operator.
Let me stop you there for a minute. How long do we agree or pretend that this was a routine traffic stop? Because it really wasn't. There was a tip. So routine traffic stop, yeah, they
That's the
see
other
a
case.
traffic violation, right? Oh, the other case, sorry. Never mind.
I'm relieved, Your Honor.
Okay, so you've got a routine traffic stop.
The other case, huh?
So in these circumstances where the police officers, as they're approaching during this stop, of course, somewhat unique that he pulls into this driveway, but the officer doesn't place special significance on that particular fact. But as he's approaching, he gets to it, the defendant opens the door, steps out, turns toward him. I'd suggest that alone is a suspicious circumstance.
Turns towards the police officer.
Towards the police officer. The door remains open, he stands facing the officer.
But if he turned away from the police officer, that would be more concerning. His hands would be not visible.
Well, I would suggest that if he turns away from the officer, of course, if he's hiding his hands, that's something of a separate factor. But if he simply turns away and is walking into the residence or walking
But
away.
if he gets out of the car and his back is to the cop, that's a big problem, right?
That's a problem as well, sure.
Okay, as opposed to getting out of the car like any normal human being would be and say, hey, what's up?
Well, I'd suggest in the circumstances of this case, there's not a strong case to be made that he's simply exiting the car to engage with the officer
How do you
regarding
know
the
that?
traffic stop. I apologize.
How do you know that?
Well, I don't know it. But neither furtive movements, we don't know that that's.
Heard of about getting out of the car. Is that the problem, that he got out of the car?
Getting out of the car at the timing.
He was cooked after he got out of the car, in other words. There's nothing he could do right. What could he have done otherwise?
Well, I think the ordinary course is to remain in a car during.
Okay, so
during a
that's
traffic
my
stop.
question.
Sure.
He got out of the car, that was his problem, that was his sin.
Well, so we're not necessarily talking, innocent factors can lead to reasonable suspicion. So I wouldn't necessarily categorize it as a sin, but he exits the car, turns toward the officer. At that point, officer just says, don't move.
And he doesn't.
He does not move. That's right. But after exiting the car, and actually, let me take a step back. I did discuss this with defense counsel, but I do want to clarify the record on this one point, because in the judge's factual findings, he finds defendant exits, officer, and as to the sequence of events, the officer says don't move, and then the defendant looks back into the car. So I do rely on that factual finding in my brief, not heavily, but I do rely on it. And after reviewing the record again, I don't think that's supported by the record, that sequence. So I think the looking back into the car takes place before the order to not move.
But what does that all add up to? He exits the car and he looks back into the car. And that's enough to establish that he's armed and dangerous in an ordinary traffic stop?
Well, it's not enough to establish that he is armed and dangerous. It's enough to establish reasonable suspicion of that fact. We do have to take a step.
Wait. Reasonable suspicion that he's armed and dangerous, or do we just need to get to a reasonable belief that he's a danger?
Reasonable suspicion that he's armed and dangerous, and that's a point that I have conceded in my reply brief. I agree with the defendant's assessment of that issue. But we really have to account for the area he's in, and I hesitate to just call it generically a high crime area because that does not fairly address the situation, right? And I know we're hesitant to place too much emphasis on this particular factor, but when we look at the exact circumstances that this officer actually faced, not that he says there are some arrests here, a lot of arrests, high crime area. This officer, on average, participated in taking an illegal firearm off the streets every 3.5 weeks. This was not a distant, remote possibility that this might happen, right? And so in that context, he stops this, he gets out of his car, approaches this vehicle, the defendant gets out unexpectedly, right? From the officer's perspective, the defendant's motive really is not relevant here. With the officer's perspective, he's at the rear of the car at the time the defendant exits, within 10 feet of him. At that point, the defendant exits, faces him. Then repeatedly looks back into the car. Is it possible?
The repeatedly, I read the motion here, and it's not clear what he did. I know he said he looked into the car. I don't know if, because to me, what's significant is whether or not there's an indicia of danger in that they can't see his hands, if there's blatant so-called conduct. I'm not getting any of that from looking into the car. Are you? And the judge doesn't make any findings about that.
No, but from repeatedly looking back into the car, I think it could be inferred, at least from the officer's perspective, the defendant is considering going back in or getting something from the car.
Well, I think the police officer testified that in his experience, when someone looks in the car, they've got something in the car that they don't want the police to see.
Right, initially trying to distance himself from some contraband, and then repeatedly looking
He doesn't
back.
say a weapon. He says contraband.
No, that's right. But that's all furtive movements. Furtive movements relate to either hiding contraband or a threat to the officers, and it has to be consistent with both of those. But it
has to equal danger.
Well, what I'm saying is an individual factor doesn't have to equal that. It can be right. Furtive movements have always been related to, yes, it's contraband. It could be a weapon.
The bottom line is we have to look for dangerous conduct.
Correct.
Wait, what's the furtive part? Because he got out of the car and he looked back in the car. I'm just trying to figure out what's furtive about either of those.
Well, if we define furtive, and this is probably part of my concern with focusing too much on these technical factors, right? Because we're concerned about what these officers actually confronted.
Right.
But furtive has been defined as either hiding or threatening to the officer. And in that context, I think that this could be fit into the category of furtive.
Doesn't furtive mean secretive?
The dictionary definition would say that, Your Honor, but I think as the term of art.
Because if someone raises a hand at a police officer, sticks their hand in full view to a police officer inside their jacket pocket, that's not furtive. That's dangerous.
No, the court.
But furtive is usually they roll up on a car and all of a sudden they're making movements or hiding something, and we don't know what they're hiding. I get that, but I think Justice Budd's question you haven't answered is what is furtive about doing everything out in the open?
Sure. Well, it isn't secretive. I would suggest that it arguably under as that furtive term has been used as a term of art in the reasonable or the stop and seizure context, it could be characterized as furtive.
Well, maybe we need to clarify that then.
Perhaps, but I think regardless, what we're concerned here is with the totality of the circumstances. So whether we characterize it as a furtive movement or otherwise, I'd suggest that exiting the car can and should factor into your analysis.
But what's unusual, and again, not to confuse this with the next case, but the next case is speaking of an exit order. Generally, police want people out of the car because they can't drive away. They can't use the car as a weapon. In this particular case, they can see the person's hands more clearly. You would think the police would be encouraging people to leave the car when they confront the officers, because that avoids the need to decide whether to do an exit order. Why is that, why does that add to the reasonable suspicion?
Well, it's certainly in some circumstances, an officer might prefer to be able to see an occupant of a car outside of the car, but I don't think that changes the fact that the timing of exiting when the officer is approaching, and he's that close, and getting out of the car and facing the officer, from that officer's perspective, that's alarming conduct.
So you said in this case, it's the location of where the officer is and where the car was and where the defendant was. Is that it? It's the location and the approach?
Right, is a part of the analysis when we consider what's suspicious about him getting out of the car.
And how does that play out vividly? Like, if you had to describe it to your elderly grandmother who didn't understand.
The police officer gets out of the car during a routine traffic stop and begins to approach as you would expect in a routine traffic stop. So he gets out of the car, and at the point that he reaches the rear of the defendant's car and is within 10 feet of him, the door opens, the defendant stands out and faces him. Of course, it's a possibility that the defendant believes this is the appropriate conduct during a traffic stop. It's also reasonable from the police officer's perspective to see this conduct as being consistent with the confrontation. When the defendant then repeatedly looks back into the driver's compartment of the car, and the police officer has already told you, has testified that the exiting alone raises some suspicion that there's contraband in the car, then that adds to the suspicion.
But contraband in and of itself doesn't lead to the idea that it might be dangerous contraband.
Correct. The exiting, facing him, possibility of confrontation, and repeatedly looking in. But where we are talking about reasonable suspicion, the suspicion doesn't necessarily, of course, at the end result, he has to have a reasonable suspicion that a defendant is armed and dangerous.
But police aren't shy, and police aren't ill-informed. They know when there's a confrontation, and they'll so testify in court. The person got out of the car. They clenched their fists. They did something, and we have none of that in this case. So when you say that the police officer thought this was a confrontation as opposed to the person doing whatever he thought you're supposed to do in a traffic stop when you have a broken windshield, that's not really what we have in front of us, is it?
Well, I think that again, I'd go back to my opening where, yes, it's nice when we can look back to a prior case and say, hey, this conduct fits neatly into that conduct. But where we have to do, that's why the court, I'd suggest, has emphasized over and over again, these are such fact-specific, intensive inquiries, because the facts are never identical. And so, no, in this case, the officer doesn't say he had a bladed stance, or he was hiding hands behind his back, or that he clenched his fist. He describes different conduct, but I would suggest in this context...
I mean, I get that they're taken aback, that they come up and they want to control the scene. They want to tell people when to get out of cars, when to stay in the cars. They're surprised that he unprompted gets out of the car. But does surprise equal danger?
Well, I think in this case it would, because that surprise, why is he surprised? Because it's so unconventional, and because he has to make this decision in a split second. Again, within 10 feet. If this defendant is confrontational, he doesn't have time to weigh all these factors in great depth.
Right, but I think you'd probably concede, and you'll tell me if you wouldn't, that while getting out of the car can be added to the calibration, that in and of itself, it's not enough. And I also appreciate how you've recognized that we can't put too much into whether it's a high crime area, and you've distinguished this situation. But in a way, you are and have to put a lot into the high crime area, because just looking back X amount of times and getting out of the car in a driveway, which is less strange than maybe on the side of the road, but nonetheless, getting out of the car, I mean, that's not going to get you to reasonable articulable suspicion, armed and dangerous. So you need to be able to get enough to be the high crime area. And we've obviously, relatively recently, for good reason, said, well, it's not that it's not a factor, but it can only do so much. And here, it really has to do so much to help you, doesn't it?
It has to do some work here, Your Honor. It certainly does, but that's why I'm pointing to that this isn't generically described as a high crime area. When we look at cases that otherwise that have described it, sometimes, and I'm blanking the case at the moment, but there had been some violent crime in this area. He had made arrests for violent crimes, and he'd been in the area for 4 years. Right here, we're talking about. He says close to 30+ firearms that he personally has been involved in recovering in this neighborhood in 2-year period, right? It's such a real concrete threat when he makes a traffic stop that someone in the car might have a weapon. And I don't think that fact can be ignored, and I don't think it can be just lumped in with high crime area fits into these other cases with high crime area, because I do think it's distinct.
You'd have a much better argument, though, if the police officer knew this defendant, right? Knew that this defendant had a criminal record or had confiscated a firearm from this defendant before. Here, he doesn't know the defendant at all. He doesn't recognize him, doesn't recognize the car or anything.
That's right. That's correct.
Is there a racial aspect to this?
Is there a racial aspect to it? I think that some of the amicus briefs, or I believe both amicus briefs raise an issue. This is a concern and a reason for you to give weight to the defendant's arguments here. I do think.
Was the defendant a person of color?
I really don't remember. He may have been described as a Hispanic male. That they described seeing him vaguely when he drove past them, and then really not getting a good look at him until he gets out of the car, I believe. I believe they observed, and I don't remember if they say how exactly they describe him when he's driving the opposite direction of them.
I guess one other question. If the looking back in the car suggested maybe contraband in the car, then what's the justification to be pat frisking his person, as opposed to saying, step away from the car, sir?
Well, I don't know that the court's ever spliced it quite that finely in that momentary analysis that he can't grab him, and just the fact there might be something in the car doesn't preclude the fact there's something on his person, right? If he was pat frisking someone and he finds contraband, doesn't mean he can't complete the pat frisk of his person. And I think that's essentially what's happening here. Once that suspicion is raised, I think it's a reasonable search to check his person. In this case, that's what ends up happening. He finds a knife on his person and a firearm in the car.
All right, thank you.
Thank you.
Ms. Ward.
Good morning. May it please the court. Claire Ward on behalf of Manuel Torres-Pagan. The police here did not have reasonable suspicion that Manuel Torres-Pagan was armed and dangerous when he pulled into a residential driveway, stepped out of his car, and the police immediately handcuffed and pat frisked him. The prosecution has conceded that armed and dangerous is the appropriate standard here under the Fourth Amendment to the United States Constitution and the case law of the U.S. Supreme Court, at least in 2009 with Arizona v. Johnson. And to reiterate the undisputed facts here, it was daylight. It was approximately 5:11 p.m. It was a residential neighborhood. Mr. Torres-Pagan was being pulled over for a crack in his windshield and a failed inspection sticker, purely civil motor vehicle violations. There were 2 officers in the squad car and only Mr. Torres-Pagan in his vehicle. And when Mr. Torres-Pagan got out of his car of his own accord, as has been noted here, there was no exit order in this case. And once he got out of his car, police could see his whole body, including his hands, and he followed directions. He was cooperative, and he didn't move with any urgency or attempt to try to move away from the officer or the car after told to stand still. Now, the prosecution has claimed that this was a so-called high crime area, and this court has made some extensive case law about the weight to give to a high crime area. as we know, citizens do not lose their constitutional rights simply because they live in a so-called high-crime area. And the data shows, as the CPCS amicus brief in this case pointed out, that a high-crime area is a better correlate for race of a suspect than it is for the actual crime rate of the location where the person was stopped. And in this case, the judge did make a finding that this was a so-called high-crime area, and there was testimony as to the offenses which this officer had experience with in this area. However, this area, quote-unquote, as I'm saying it, was not defined. And so we don't know if this 30 firearms in 2 years that this officer had confiscated was in the entire city of Springfield, was within this 3-block area which occurred in this case, or some other unknown area.
Can I take you for a moment back one step beyond the high crime area, back to just the getting out of the car? And that is, the appeals court relied on Commonwealth versus Douglas to say that by itself, getting out of the vehicle is an indicator of danger. Do you remember any of the facts of Douglas and how this might be similar or different?
My recollection of Douglas was that in Douglas, it was a passenger in the car who, while officers were speaking with the driver of the car, of his own accord, got out of the car, was ordered to get back in, and was eventually ordered out of the car and stopped at that time. And of course, that is not at all the case here.
Right, I know. So I was just curious about the reliance on that case.
Of course.
Whether it held up.
Of course. And the prosecution has claimed that looking back at the car was suspicious, that as he's standing next to the car, it seems that the door of the car must have still been open, and that he was standing between the door of the car and the body of the car, that looking back at it was somehow suspicious. The judge at the motion hearing considered these facts, heard all these facts, included them in his findings of fact, and did not find that this was a so-called furtive gesture. And he said that it was, quote unquote, somewhat unusual for Mr. Torres-Pagan to have gotten out of his car and to have looked back at it once he got out. I think that that finding is entitled to deference. The judge was in the best position to evaluate the testimony and to evaluate the credibility of the people who testified.
The timing of looking back at the car and when it happened compared to the findings, that difference inures to your client's benefit.
If you're asking about the concession which was just made earlier.
Yeah, that's helpful to you, isn't it?
Yes, that the testimony as it came out was that Mr. Torres-Pagan got out of the car, looked back at the car, and then was ordered to stop.
Right.
And the testimony stated that he was, in fact, cooperative with the order to stop. And that I believe the judge's finding was the opposite, that he was ordered to stop and then looked back at the car. But as Mr. Shorey stated, that's not supported by the record. So the motion judge did not consider it to be a furtive movement. And as has been pointed out, it's in fact an overt movement. He's making himself more visible to a police officer. You can see his hands, you can see his whole body, and it's a very different circumstance than the classic case law on furtive gestures, furtive movements, where a person is ducking down out of sight or fiddling around with something in their pocket that police can't see. So again, this was not a furtive movement, it was simply an overt movement getting out of his car. The prosecution claimed in their brief that the timing and action of Mr. Torres-Pagan getting out of his car was, quote, uniquely consistent with a plan to attack. And this, I think, just really pushes the boundary on what we expect of normal human beings. At 5:11 p.m. in a residential driveway, when a person has just parked in their driveway, and the testimony at the motion hearing was not at all clear that Mr. Torres-Pagan knew he was being pulled over when he stopped his car.
And there is
got out.
testimony that this was his driveway, is that correct?
There's no, it's not in the record whose driveway this was. But here it is, 5:11 PM, and he gets out of his car in a residential driveway. It seems consistent with a plan to go home from work.
Were there lights and everything on the police car?
The police car was equipped with lights and sirens. They only
Use them?
turned their lights on, not their siren, and they turned their lights on approximately 8 car lengths before Mr. Torres-Pagan parked.
Could he have parked in response to that?
It's possible,
Yeah.
but it's not in
What
the
kind of a
record.
road was it?
I'm sorry?
What kind of a road was it?
It was a residential side street.
Side street, okay. Not a busy street.
There was no testimony that it was a busy street. And the motion judge found that the decision to pat frisk the defendant was not based on a reasonable concern for officer safety, because he found no furtive gestures, because he found that it was not threatening or hostile for Mr. Torres-Pagan to get out of his car and look back at it. I believe the judge's finding was, quote, on one or more occasion. And the Commonwealth in this case is asking this court to second guess those findings of the motion judge. And the motion judge made his decision under a lower standard, because now both myself and the prosecutor are asking this court to impose the armed and dangerous standard for every pat frisk, whether or not it comes in conjunction with an exit order or a car stop or your classic Terry stop on the sidewalk.
Well, isn't that the rule?
It is the rule, and it has been inconsistently applied in Massachusetts, especially with regards to pat frisks following exit orders. And for that reason, in the courts below, there was some confusion, I believe, about what the correct standard for this pat frisk must be. And it must be armed and dangerous. And even if, as I believe Justice Gaziano asked Mr. Shorey just previously, even if you believed that it was an indication of danger that Mr. Torres-Pagan got out of his car, it cannot be an indication that Mr. Torres-Pagan was armed. It cannot be an indication that Mr. Torres-Pagan had a weapon on him, and that's why he got out of his car. So I think that conjunctive armed and dangerous test is especially important in a case like this, where perhaps the police are surprised by the actions of a defendant. But that surprise, while it may in some cases rise to the level of an indication of danger, it gives no indication that this defendant was armed.
When you use the word armed in this context, do you mean armed on his person, or could he also have been armed by having a gun under his seat?
I believe it to be on his person, because that's the Terry, that's what Terry was talking about.
But clearly, if they had reason, and I'm not saying that's the case, but if they had reason to believe that there was a firearm or a weapon within the passenger compartment of the car, they would have a right to seize him to prevent him from reaching that weapon, right?
And as you pointed out earlier, they could have ordered Mr. Torres-Pagan to step away from the car.
Right, there's that. That was the chief, we get confused all the time.
I'm sorry.
But the police don't have to say, if they think there's a weapon on the driver's seat, they're not going to say, "Excuse me, sir, may I grab the weapon?" They can grab the guy, right?
If police see a weapon, of course.
Right.
And if they have...
Or reasonable, anybody, but that's not this case.
That's not this case. And those are the reasons specifically why the officer here in his testimony said, I had no idea if there was a weapon in the car. I didn't know what he might have been looking back at. And I believe he did use the word contraband.
Yeah, he said contraband.
That he believed there could be contraband in the car. And again, a pat frisk cannot be used as a method to find contraband, right? It can only be used by police to secure their own physical safety in the context of a brief detention, a brief encounter. And so it wouldn't have been an appropriate purpose to conduct a pat frisk in order to find contraband. So the motion judge's decision was, I believe, clearly reasoned, and his findings of fact are, should be accepted absent any clear error. And I think we've only pointed out one instance which we don't believe rises to the level of clear error, where there may have been a difference between the transcript and the judge's findings. But this court should grant substantial deference to the motion judge's findings of law. And of course, we are asking for a different standard here. We're asking for the armed and dangerous standard, and that is a higher standard because it is conjunctive. It
Wait,
requires two
So
things.
I thought that was the law, armed and dangerous for pat frisk.
Yes.
So what are you asking for?
The judge did not use that standard
Okay.
when he made his decision.
What standard did he use?
The judge used the standard that the decision to pat frisk the defendant was not based on a reasonable concern for officer safety.
Well, I mean, he's using the exit order law, which
Yeah.
causes some confusion, but
Right.
you've clarified that, and there's a concession.
Yes. Yes. So for all of those reasons, we're asking this court to affirm the judge's order to suppress both the pat frisk and everything that was found thereafter. If there are no further questions, I will rest on my brief.
All right, thank you.
Thank you.